Good morning, everyone. Good morning, and welcome. We are so glad that you decided to join us on this Saturday morning. We are excited today to have our special guest with us, our special speaker with us on today. And so I would like to welcome everyone here on behalf of our pastor, Reverend Roscoe Perry, and our First Lady, Mrs. Ann Perry. We'd like to welcome you all to protecting your lifestyle, your loved ones, and your legacy. So we're going to move forward. I am going to have Mrs. Brenda Wright come up, and she's going to open us up in prayer.
Good morning. Would you just bow your heads and just a word of prayer? Dear most precious Heavenly Father, we come to you this morning. Dear Lord, so humble that you saw fit to wake us one more time. So humble that you saw fit for us to gather, dear Lord, in your name, dear God. Heavenly Father, we just ask that you just guide the speaker's words, her mind, her thoughts, dear Lord, as she imparts on us the wisdom that you would have us to know, dear God. We know that you are an awesome God and you are mighty, dear God. So we lift everything up to you, dear Lord. We give all things to you, dear Lord. We know that you would never lead us in a path that's not of your will, dear Lord. And we ask that you just continue to guide and be that light, dear God. So cover this meeting, dear Lord. Cover the speaker, dear Lord. Cover us, dear Lord. Block out any distractions, anything that would take us away from what you would have us to know and any revelation you would give us, dear God. So Heavenly Father, we ask all these things in your mighty Son, Jesus' name, dear Lord. Amen.
Amen. Thank you so much, Miss Brenda. And so we're going to move right along because we want to make sure that you receive this great wealth of knowledge. So I'm going to go ahead and introduce to you our speaker for today. So Dion Tracy Duckett is an elder law and estate planning attorney with offices in East Point and College Park, Georgia. She is licensed to practice in Georgia, Maryland, and the District of Columbia, and is also a Veterans Administration accredited claims attorney. Dion was born in Hartford, Connecticut, and moved to Atlanta when she was 5 years old. She was raised in Atlanta, where she attended L.O. Kimberly Elementary School, Woodward Academy, and Benjamin E. Mays High School. She earned her law degree at Howard University School of Law, where she served as special articles editor for the Law Review and was elected treasurer of her class for 2 years. She earned her MBA in accounting from Morgan State University and a BA in computer science from Goucher College, where she enrolled early after completing the 11th grade. She earned her LLM in elder law and estate planning at Western New England School of Law in May of 2023. Dion has a variety of legal and non-legal experiences. Upon completion of law school, she served as a corporate associate for a major Maryland law firm. She also served as a staff attorney for the United States Court of Appeals in the 11th Circuit. Dion returned home to Atlanta in 2015 to be closer to her family. Her family was her motivation for starting her practice in elder law and estate planning. Dion's youngest sister has Down syndrome, and her father had Alzheimer's disease. Additionally, she has a nephew who has Down syndrome and a niece who has autism. Through her personal and family experiences, Dion has become well acquainted with the concerns and needs of our seniors and family members who have special needs. As an elder law and estate planning attorney, her mission is to help people plan for the protection of their lifestyles, their loved ones, and their legacies. And also, Dion Tracy Duckett is also a member of the first and the finest sorority of Alpha Kappa Alpha Sorority Incorporated. So Miss Dion is also my soror. So we are so grateful and thankful to have her with us today. So I present to you Attorney Dion Tracy Duckett.
Thank you, Sora Veronica. I'm going to start off up here. I don't know if I'll stay here, but I really appreciate you having me here today. I'm excited to present. I try to take an educational approach with my practice. When my father developed Alzheimer's, and that's my motivation. We went to an elder law attorney who was very good, but we had to go to the other side of town, so there's no one in our community. And that's why, and I need to update. My office is in Atlanta now, but it's only 5 miles from where it was before. And I've started a virtual office here. My mother's family is from Mount Carmel, South Carolina, and so that's only 25 miles from here. So I thought I might like to move out this way where it's a little, Atlanta's kind of outgrown me. But I'm happy to be here today. I'm not going to talk a whole lot about me. I'd like to get started. I am an attorney, so we're going to talk about estate planning 101 today. And you've already heard my background, but I also want to start with a disclaimer. You know, we attorneys always have the small print. So this presentation for today is for educational purposes only, and you should not take anything as legal advice about a particular matter, because everything depends on your particular facts. In addition to that, if you have questions, if they are particular to your circumstances, then those I may not be able to answer here. Those might require a one-on-one consultation. So if you ask a question, if it's something that you're thinking on that's going on in your life right now, then it's probably not a question that I can answer today, because that would be legal advice. So please, if you have particular questions, you should consult with your advisor, whether it's a legal advisor or a financial advisor. Okay, so I want to start, and the other thing is I'd like to hold questions to the end, because I have a lot in this presentation. I'll probably answer a lot of the questions as we go, but then at the end we'll do questions. But I do like to be a little interactive, so we're going to start with, what is your estate? Anybody? I heard someone say home, property. Yes, ma'am. Yes, so that's exactly right. So your estate is basically everything that you own. It includes your assets, but it also involves, your loved ones aren't part of your estate, but it involves your loved ones, your values, and your legacy. And that's why we talk about, in our practice, we talk about protecting your lifestyle, your loved ones, and your legacy. And when sometimes people ask me what legacy means, and it doesn't necessarily mean the property leave you behind, it can also be your values or whatever you want to be remembered by or instill in your loved ones. Okay. So, I want to ask, what are the reasons that you should plan? Anybody? Okay, I heard so that your wishes are carried on. I didn't hear you. Okay, no bickering if you've planned everything out in advance. Family peace, family harmony. Could you say that again, please? Okay, minimize tax implications in passing on your assets. All right, so how many people here have an estate plan? Show of hands. Okay. All right, so a lot of hands were missing, and the truth of the matter is 62% of Americans have not done any type of formal estate planning, but everyone has an estate plan, okay? Because if you haven't done your planning, the state has one for you, okay? So when we talk about reasons to plan, and also it's not just about planning for what happens to your stuff after you die. What happens if you live? Okay, so what happens if you become incapacitated? So reasons to plan include designating who you want to care for you and for the people you take care of after you die. I mentioned that, or if you should become incapacitated. I'm the oldest of 7, and I'm 20 years older than the baby. So my youngest sister has Down syndrome. My mom will be 82 this year, and my sister is 38, and they've been joined by the hip since her birth. So what happens if something happens to my mother? Who's going to take care of Stacy? Who's going to take care of my mom? Also to designate who you want to manage your estate when you die. I heard that one. to designate who you want to care for minor children or children with disabilities, and to give what you want to whom you want, the way you want, and when you want to. Okay, and then we talked about what happens if you don't plan. There's possible expensive court proceedings like probate, or and there's living probate, the conservatorship process if you become incapacitated. The court will decide, that's the plan I was telling you about. If you haven't laid out your plan, the court has a plan for you. If something happens to you and you lose capacity, the court's going to have probate process to appoint a guardian or a conservator or both. And the state's going to determine who receives your property after you die. So who should plan? Answer's there. Anyone who's over 18 years of age. So if you have children going to college, my niece was in town this week. She started Spelman this week. But once your child turns 18, they're an adult. And so you can't make decisions for them anymore. You can't have access to their records without their permission. So what happens if they become incapacitated? So at a minimum, they may not have things to pass on, but they need to have powers of attorney, advance directives in place so that if something happens to them. And like we mentioned earlier, it's not just about planning for death. What happens if you become incapacitated? And a lot of times we don't start thinking about planning until we get older or something happens, but you want to do it before something happens. We had a family friend. He was only in his 20s, and he was in a car accident with a drunk driver driving in the wrong lane. And he was unconscious. He had a new job, new apartment, new cable bill, all of those things. And he was in a coma, and when his parents tried to disconnect all of those bills that were just racking up, they were like, "Where's your power of attorney?" Fortunately, he woke up. He's fine now. He married, has a child, but he didn't have any planning in place. He was 20-something. Who's thinking about that in 20-something? I know I wasn't. So threats. Let me ask you, what are some of the threats to your estate? What was that? Scammers. That's true. Taxes. The state itself. What was that? Yes, you could be sued. Exactly. And so when we're planning for our own protection and for the protection of what we are leaving behind. So some general threats to your family's inheritance are incapacity. If you become incapacitated, what happens if you have to pay for care? What happens if you have to go into a nursing home? Does anyone know the cost of nursing home care in Georgia? On average, it's between $8,000 and $10,000 a month. Yeah. So, and if you're married and you have to go into a nursing home, then what about the spouse who's still at home? If you're spending that type of money. Immature heirs, you may have grandchildren or children who are too young or not mature enough to receive substantial inheritance. Spousal remarriage, what happens to your estate if you die and your spouse gets remarried? We'll talk more about some of these things. Blended family issues, that kind of goes hand in hand with the spousal remarriage. Irresponsible spenders. They could be full-grown adults but not responsible. Substance abuse issues and self-serving caregivers. That goes in line with the scamming. Okay, so there's basically two foundation ways of planning. One's with wills and one's with trust. Does anybody know or have worked with either? Okay, I see people who have wills. All right, so basically a will is a legal document that provides how you want your property distributed when you die. And it also, if you have minor children or incapacitated children who you care for, that's where you can designate who you want to take care of them if you're no longer here to do that. It also, probate is required. So a lot of people think that once a will is in place, the executor can just take that will and do what it says do. But the word probate actually means to prove the will. So when there's a will in place, you have to file a petition in the court, and then the judge has to determine that it's valid, and then the executor will be appointed. We'll talk a little bit about the probate process. Has anyone here had to deal with the probate process? I see a few hands. How long did it take? I heard somebody say too long. On average, it takes about 1.5 years. And that's if nobody's fighting and everything's going smoothly. All right, so when we talk about probate court, there's 2 types of probate. There's living probate, so that's if you become incapacitated and you haven't done your planning. Then the court will have to put a guardian. You have 2, a guardian or a conservator, or both. A guardian is a person appointed by the court to manage your care, and they make decisions for you on your behalf. And in fact, your ability to make those decisions is taken from you. A conservator is a guardian of the property. So that's where a court appoints a person to manage your property for you. And then there's death probate that we just talked about. That's where if you have a will. If you don't have a will, it's called intestate administration. The process is about the same. I'm asthmatic. I have to drink a lot of water. The process is about the same with probate and intestate administration. So the word intestate means to die without a will or an estate plan in place. And when you die intestate, that's where the state's plan comes in. The statutes, the legal statutes, actually have rules about who are your heirs and who your property will be going to and how it will be divided amongst the people it goes to. In the probate process, the court appoints the agents. The agents can be family members. They can be someone else. They can be, and the types of agents, we talked about the guardian and the conservator. The executor is the person appointed under your will. It's called an administrator when there is no will. And both the executor and the administrator are referred to as personal representatives. And the people appointed can be family members, they can be friends, they can be total strangers. So if your family is fighting, the court may appoint the county guardian or the county conservator. So it may be a total stranger who gets appointed. And sometimes creditors will even file. If nobody's gone to probate your estate and there's money owed, creditors can file and have somebody appointed. It's a public process. So once you file your will in the probate court, anybody can go there, your nosy neighbors or anyone else. You probably have people, how many people are homeowners or have family land? You get those telephone calls, people trying to buy your property every day. And so there are people who are paid just to watch the filings in the court. So they will start, as soon as a petition is filed, they will start calling, even before the person has been appointed. Let's see, and cost. So costs related to probate, whether it's guardianship or conservatorship or estate probate, include court fees, include publication fees. Usually notice has to be published in the newspaper. They could include attorney's fees. And let's see what else we have. Bond, when it comes to conservatorship or the will, when you're dealing with property, a lot of times bond will be required. And the bond is basically insurance to make sure that the person appointed doesn't do something inappropriate, or if they do, it provides insurance to cover that. And then there's attorneys and other professionals. Then the time. We talked about the time for probate. On average, that takes about 1.5 years. With COVID, things took a lot longer. In Fulton County, they're so far behind that next Saturday, they're actually going to be open for attorneys and their staff to come in and try to start catching up on stuff. So it takes a while. And then also, So the living probate process, when we talk about guardianship conservatorship, there's emergency process. That's appointing someone for 60 days when there's imminent danger. There's a very high bar for that, but if an emergency crisis has come up, that usually a hearing is granted within 3 to 5 days. It has to be held within 3 to 5 days. But a regular guardianship conservatorship process, that can take months, weeks to months. I had one that recently we started in August, and the person was just appointed last month, and the court still hasn't issued the order. So it can take some time, and there was no fighting. And then death probate can take months to years. On average, it takes 1.5 years, but at a minimum, it takes about 6 to 8 months. Talking about probate property versus non-probate. A lot of times people want to avoid probate. So when we talk about the word testate, that means to die with a will or a plan in place. Intestate, like we said, means to die without a plan in place. Probate property is property that's titled in your name alone at the time of your death. And that property has to go through probate. Non-probate property, probate property will pass by operation of the will, if you have one, or by operation of the statute, if you don't have one. Non-probate property will pass outside of the will, and it includes property that has beneficiary designations, such as life insurance or your retirement accounts. If you have beneficiary designations, it doesn't have to go through probate unless your beneficiary is predeceased you and you haven't named a contingent, or you've named the estate. So you typically don't want to name the estate, because if it's the estate, it's going through probate. Property that's jointly owned. So if your property is jointly owned with rights of survivorship, so we're talking about joint tenants, if real estate, we're talking about joint tenants with rights of survivorship. It will automatically, when one person dies, go to the survivors. There can be more than 2 owners, there can be 3 or 4, but basically the last person owns the property, and then if that person doesn't plan, it's going to go through probate. Beneficiary designations, we talked about that. Payable on death and transfer on death designations. Those are very similar to beneficiary designations. You can put that on a bank account or other types of accounts. And then trust property. If you have not been familiarized with trust, a trust is a separate entity. So when you create a trust, you transfer your property to the trust, and now you don't own it, the trust owns it. And so we talked about probate property being property that's titled in your name alone at the time of your death. So if it's owned by a trust, it's not owned by you, and it avoids probate. And there's one, when we were talking about real estate, so there's a few ways people can own property jointly. Joint tenants with rights of survivorship and tenants in common. So the rights of survivorship is what allows it to pass automatically to the other owner. When it's tenants in common, it doesn't work that way. And so it really is important to look at your deeds to see how things are titled. Because if it doesn't say with rights of survivorship, then the other person's share can be passed by their will, or it can be passed by statute. They can sell it. Sometimes one person may own 25%, the other person owns 75%, or something like that. So it depends on how the property is titled. Cost of probate. Okay, so when we talk about the cost of probate, you've got court costs. Filing fees are usually around $300 to $600 and up. It depends on how many notices have to go out, how many proceedings there have to be, if anybody files what we call a caveat, which is an objection to the will or an objection to the petition. And then there's executor fees or personal representative fees. It's 2.5% of the cash received by the estate and 2.5% of all the cash that goes out. And then there's up to 3% for the value of other assets, like if you transfer a house without selling it. 10% of interest earned on money that is loaned to the estate by the executor. A lot of times, people don't have access to the funds, and so they will start the petition process, pay the attorney's fees, and so those are loans to the estate. Publication fees, those are usually around $75. When you file for probate, you've got to file a notice to debtors and creditors in the newspaper. Sometimes a notice that the petition has been filed also has to go in the newspaper. Attorney's fees, those can be $3,500, $5,000, and they go up. Usually it's charged hourly. The bond, there's usually a bond, so that is often, I think, about 10% of the assets in the estate. And then we talked about the time. There can be mandatory reporting, which requires you to file an inventory of the estate and accountings every year until the estate is closed. And like we talked about, it's a public process. Okay, here's an example, the cost of probate. So if you have an estate that has cash assets of $100,000, non-cash assets of $300,000, then this is the calculation of just the executor commission. So we've got savings account with $50,000, checking account with $25,000, CD with $25,000. Then you've got non-cash assets, including investments of $50,000, a house worth $250,000. So the executor's commission on $14,000 would be about 2.5% of the $100,000 that went into the estate, $2,500. 2.5% of the $100,000 that goes out, whether it's in distributions or to pay debts, and 3% of the $300,000, which is $9,000, for a total of $14,000 of commission entitled by the personal representative. That doesn't include your attorney's fees, your court fees, and other fees. So it can be costly. Avoiding probate. So we talked about different ways. So one way to avoid probate is to make lifetime gifts. So you can give people property while you're alive. You can also, we talked about joint tenants, joint ownership with rights of survivorship, beneficiary designations, and trust. We'll talk about each of those things. So problems with lifetime gifts. There was, someone said one of the reasons you want to plan is for tax purposes. So you think about capital gains taxes and long-term care planning. So with capital gains, I like to use the example of my parents' house. They bought the house in 1972 for $75,000. If they sold it today, it'd probably be able to sell for $575,000. So the capital gains calculation, what they bought it for is what's called their basis, the $75,000. When they sell it for $575,000, the calculation starting point is the fair market value, $575,000, and they subtract the basis, the $75,000. So that's $500,000 that's potentially taxed. Now, there may be some exemptions and things after that, but we're talking about $500,000. So if my parents gave me the house today and then died tomorrow, my basis would be their basis because they gave me the house while they were alive. So I would get that $75,000 basis. And if I turned around and sold it tomorrow for $575,000 after, if I turned around and sold it tomorrow, then my calculation would be the $500,000 minus the $75,000, $500,000, and then if there's any exemptions or anything, that would be applied. If instead I inherited it from them and they passed today, I would get what's called an adjustment in basis. So my basis would be the fair market value on the date of the death, which today is $575,000. So if I turned around and sold it tomorrow for $575,000, my calculation would start at $575,000 fair market value minus the $575,000 basis, 0. So there's a big difference in giving things while you're alive, or can be a big difference, giving things while you're alive versus giving things after you die. The other thing is long-term care planning. We talked about the cost of nursing home care. The ways to pay for nursing home care, that $8,000 to $10,000 a month, is to use your income and life savings or family assistance, or if you have long-term care insurance, which is a very good thing to have, My understanding, the sweet spot for getting long-term care insurance is between the ages of 55 and 65. After that, it becomes more expensive and more difficult to get. The third way is to apply for Medicaid, okay? And so a lot of people have concerns about Medicaid because they think it's a form of welfare. They think it's for people who don't have any property. But basically, if your income is less than the cost of the nursing home, we're talking about $8,000 to $10,000 a month, then you can qualify. So if you have income that's $7,000 a month, then you're not a poor person. So that is something that you've paid into the system for, and so you can do planning to qualify. And when you do that, when you apply for Medicaid, you don't apply, they have rules for how much you can have in assets and how much you can have in monthly income. And that's usually about $2,000 a month in income, but the excess we can plan for as long as your income is less than the cost of the nursing home care, and $2,000 worth of assets. They do, the house is exempt, and a car is exempt, and there may be some other things. But if you haven't planned, if Medicaid pays for your nursing home care, then they want to be paid back after you die. And often that means selling the house to pay back what they've paid over time. Or it can mean family members having to come up with the money or take a loan out on the house in order to pay for it. If you've planned, you can plan for the protection of the assets. Has anyone ever heard of what they call the 5-year look-back period? Okay, I see one person nodding. So when you apply for Medicaid, the day you put your application in, they look back 5 years to see if you gave things away. So we're talking about those lifetime gifts. They can look at 5 years worth of bank statements, tax returns, they're already tapped into the IRS. And they will add everything up, and they will determine a penalty period. And so they're looking for transfers less than fair market value. So if you have a $200,000 house and you give it to sell it to a child for $100,000, they're going to look at that as a $100,000 gift. And right now the penalty divisor is about $10,000. So they'll take that $100,000 divided by 10, and that'll be 10 months of disqualification that you have to pay at that full rate, which is about between $8,000 and $10,000 a month. So we're talking about maybe $96,000 or more a year. So you don't want to just start giving things away. The other problem with lifetime gifts, I had a neighbor, a real estate agent called me about, because the neighbor had transferred a property to her children, put their names on it. And she didn't realize by doing that she wasn't going to be in charge of the property anymore. But it wasn't hers anymore. And when she asked them to transfer it back, they would not. So that's another thing to consider. You may be mom or dad, but once you give it away, it's given away. Okay, the problem with beneficiary designations, outright distributions. So for instance, if you have grandchildren or minor children designated as beneficiaries on your life insurance or on your retirement, sometimes those accounts can be pretty large. Okay, some people have $100,000, $500,000, $1 million in life insurance or retirement benefits. So if your minor child receives that money, what do you think they're going to do with it? Now, they won't be able to receive it before they turn the age of majority, which is generally 18, some states it's 21. But what would a 21-year-old do with $100,000, $50,000 or more? Are they going to pay for tuition, or are they going to buy a car? Okay. And then they'll probably just wreck it when they go right out the parking lot. So you don't have any control over it. As soon as they turn the age of majority, they are entitled to receive that property. There's no creditor protection for beneficiaries. So because once the property's in their name, if they have bad debts or anything like that, they can be attached. So if there's a lawsuit against them, they can be attached. I like to use the example of a school bus. If someone is in a car accident with a school bus and they're at fault, then there's going to be a lawsuit. The first line of protection is the insurance. And so, but if several children got hurt, the insurance may be insufficient to cover any judgments. And so then any money that's available from the insurance exhausted, and then they're going to go after the personal assets of the person who was at fault. So that's their bank accounts, their personal property, their homes, anything else they may try to go after. Immature errors, and you can plan for creditor protection. We'll talk about that of your beneficiaries. Immature, irresponsible beneficiaries. So you can have adult children or adult beneficiaries who are 40, 50, 60 years old, but they may not be good or responsible with money. So you may also want to, if they receive $100,000, $50,000, what are they going to do with that? Okay, so we talked about the beneficiary designations. So trust. And I do not promote trust for everyone. So we talked about all the problems with the outright gifts and the beneficiary designations and those types of things, but just want you to know that a trust is not necessarily the best idea for everyone. It depends on your asset mix, your goals, your concerns. But trust, we talked about, is one way to avoid probate. So a trust is a way, it's a tool that can be used to separate legal ownership from beneficial ownership. You can think of it as a treasure chest for your property. And when you, how should I say this? So right now, you own your property, you manage your property, and you manage it for your benefit. If you create a trust, you transfer your property to a trust. And there's lots of different types of trusts, but right now we're talking about a revocable trust. You transfer it to the trust. You're still in charge of it. You designate yourself to manage it, and you're the beneficiary. The only difference is who owns it. So if the property is owned by the trust, it does not go through probate at the time of your death. When we're talking about a revocable living trust, it's revocable, so you can cancel it or you can amend it. You can get rid of it altogether. Living is created while you're alive, versus a testamentary trust is where you say, when I die, create this trust for that irresponsible or minor child, and put the property in there, and that way it can be managed. So there's living and there's testamentary. This takes a long time, so I won't go through the trust revocable versus irrevocable. But when we're talking about long-term care planning and that 5-year look-back period, we use an irrevocable trust for, let's go back, for the planning. So just to tell you generally how trusts work, a trust can own everything or anything that you can own. So that first house is the house that you live in. You've got the cash in your bank accounts. It can own investments, personal property such as jewelry, furniture, business interests such as LLCs, and if you have other property like rental property or vacation home or family property, it can own all of that. And that's both of them, the irrevocable and the revocable. You also have life insurance and retirement accounts. You don't generally transfer those to a trust. What happens when you take distributions from your retirement accounts? I can't hear you. Penalties or taxes, depending on if you're at the age of required minimum distributions, it's taxes. Okay, so if you transfer your retirement to the trust, that's a distribution, and all those taxes and maybe penalties will be due. The irrevocable trust has a lid on it. So once you put the property in it, you can't take it out. We talked about the revocable trust. With the revocable trust, you can stick your hand in there, you can take the property out, you can do whatever you want. But there's also potential access for creditors. With the irrevocable trust, when we talked about that 5-year look-back period, your assets, in order not to be counted, can't be available to you. So if you can stick your hand back in there to get them out, then they're available to you. So it's irrevocable. So the property you put in there has to be in there 5 years before you apply for Medicaid, and then it would be protected. You won't have to sell the house in order, or it won't even be counted as far as applying for Medicaid. You can take unlimited distributions while you're alive. With the revocable trust, you can be the beneficiary, but with the irrevocable trust, again, for Medicaid purposes, it can't be a resource for you. So someone else has to be the beneficiary. So it may be your children or whoever you want to get it at the end of the day. With the revocable living trust, you are the lifetime beneficiary. When you die, we've got this escape hatch. Your money goes out, and it goes to who you name as your death beneficiaries. Those can be people. Those can be another irrevocable trust where you're able to provide that protection for your beneficiaries. It's irrevocable, so they can't go in and take it out. It's managed for them. You can designate them as their own manager if they're responsible, but that's how you can provide creditor protection from that school bus accident, from divorcing spouses, different types of things. Or to a charity, so that can be a university or a church or something else. Only the trustee is the person you designate to manage. Only the trustee can make distributions either while you're alive or after you die. With the revocable on the left, there's no lid. You can remove the property. There's potential access to the property by creditors or others, and you can't transfer your own property to a trust and protect it. Otherwise, everybody would do that. They would make big bills, buy stuff, put it in a trust, and then not pay. So, but you can provide protection for your beneficiaries. And again, with the revocable trust, you're the beneficiary. So it's pretty much business as usual. You've just changed ownership. With the irrevocable trust, there is a lid. You cannot remove the property. Only the trustees can access. You can be the trustee. It's not a good idea, but there's no rule against it. So you can be in charge of the distributions, but you cannot be the beneficiary. So you can't make distributions to yourself. Typically, you would name someone else as the trustee, and you can have indirect access. For instance, if you transfer a property to this irrevocable trust, and then a distribution is made to your beneficiaries, it could be your children or someone else, if they then take that property, if it's cash, and put it in their own bank account, if you need something, they can pay for it for you. They can't give it to you. They can't give a distribution out of the trust to you, but they can take the money that is now in their account and pay for something for you. Primary uses for the revocable trust are asset management, incapacity planning, probate avoidance, and beneficiary protection. For the irrevocable trust, the Medicaid Asset Protection Trust, again, asset protection, property, incapacity planning, asset management, probate avoidance, and beneficiary protection. There are also other uses, but here we're talking about a Medicaid Asset Protection Trust. There are lots of different types of irrevocable trust. So the benefits of the trust. You can provide for management of assets if you become incapacitated, because just like you are initially the manager with the revocable trust, you also designate who you want to be the manager if you become incapacitated. That way you don't have to go to court and have someone appointed. You also designate who you want to be in charge after you die. So like we said, probate property is property that's titled in your name alone at the time of your death. So if the trust owns your property, it's not probate property, and you avoid probate. You can provide protection for your family's inheritance by, instead of giving those outright gifts, leaving it to them in trust. You can provoke family harmony. I heard people mention that. You can do that just by doing your planning. Also, with a trust, it's more difficult to contest a trust. than it is to contest a will. It can be done. A recap of the threats to your estate: incapacity, immature heirs, spousal remarriage, blended family, irresponsible spenders, substance abuse issues, and self-serving caregivers, to name some of them. Okay, so with incapacity planning, you want to do that in order to prevent loss of assets. Loss of assets due to the probate process, because if you go through guardianship, conservatorship, or probate, all those fees have to be paid. And also loss of assets if you end up having to pay for your long-term care or any other things happen, or if you're taken advantage of because you don't have someone in place to manage for you. So you're able to designate a successor trustee to manage your property. You do that in the trust document itself. You designate who you want to serve. So we talked about how a family member, like I said, I'm the oldest of 7, and we all get along, but we all have different strengths and weaknesses. So you may have a child who's good with money, but would be a terrible caregiver. So you wouldn't want that person to be your guardian to take care of your care, but you might want them to take care of your property. Then the vice versa may be in place. You may have somebody who's really good caregiver, but not so good with money. So you wouldn't want that person to be named to manage your property. But what if the person who's not so good with money has more money than the person who is good, okay? If they spend a lot of their own, or if they're irresponsible with their own, they may be irresponsible with yours. You can avoid the court proceedings to appoint the conservator. We talked about that. And then the documents for incapacity planning. Advance directive for health care. That's where you designate a health care agent who you want to make the decisions on your behalf. And then you want to be wise in selecting that person. You want to select someone who knows what you would want and who would honor your wishes. I use the example of my parents. My father was a medical doctor. My mom believed in holistic cures. And so if you don't want surgical proceedings and those types of things, then you would probably want someone like my mother in place. If you want to use all of the medical advances, then you might want someone like my father in place. And so you have to think about what would they do. I had a friend who told me about when his mother died, and she was saying, and this is also where you designate what you want done if you're in an end-stage condition, if you're terminal, and doctors have said that there's nothing we can do to help you get better, and if we stop treating you, this is like if you're on life support, you'll probably die in a short period of time, okay? So what would you want done? Would you want them to continue treating you? Would you want to be allowed to die naturally? Or would you want something in between, a ventilator, resuscitation? I had a friend I was telling you about, and I believe his mother was about 90, and she was saying she's ready to go. And I think she was in a lot of pain, and because he was telling me the story, and he kept telling her, no, you can't go now. You can't go now. And because he wasn't ready to let go. So that's the other thing, is you take the burden off of your family members of making that decision, and then you are also able to make sure that what you want can be done. The financial power of attorney, that's where you designate an agent to manage your property that's not in a trust. So they can write checks for you, they can pay your bills, manage your mail, and then guardianship documents for minor children. We talked about immature heirs and irresponsible spenders. So there's been a study by the Ohio State University. It was done in 2012 of people in their 20s, 30s, and 40s who received an inheritance. And so it showed that 34.9% of inheritors saw a decline or no change in their wealth after receiving the inheritance. 1 in 5 baby boomers who inherited a significant amount of money spent or lost all of it. They even say people who win the lottery, usually those funds are gone within a few years if they're not managed. The average participant spent roughly half of the inheritance. And we talked about heirs may be young when you die. They're not entitled to the inheritance until the age of majority, but then when they reach majority, if it is an outright gift, they're entitled to all of it. Grandchildren may be heirs if your child dies before them, and heirs can be infants or small children. Spousal remarriage and blended families. So if you die and your spouse gets remarried, what's going to happen to the goals that you had for your children? What's going to happen to the property that you leave behind? What if the new spouse also has children? And will your money be given to the new family? If they're a family, that's usually what happens. So a lot of times married couples do what we call sweetheart plans. So they'll go to the lawyer, and I'll use husband and wife, but it can be same sex. But just to differentiate, the husband says, when I die, I want everything to go to my wife. If my wife dies before me, I want it to go to my children. And then the wife does the same thing. When I die, I want everything to go to my husband. If he dies before me, I want it to go to our children. So then I was using this example that the wife dies first. Okay, so the wife dies. We're in church. Y'all know about the casserole ministry? Okay, anybody? So the casserole ministry is when the single ladies of the church start bringing their casseroles to the widow. So husband falls in love with the best casserole maker. And he gets married. She has children also. And they go to the, so they're one big happy family. They go to the attorney and do the same thing. He says, when I die, I want everything to go to my wife. If she dies, because she'll take care of the children. When she dies, if she dies before me, I want it to go to all of our children. Okay, wife number one is probably turning over in her grave. Okay, and so then wife number two does the same thing. Everything goes to my husband, and then if he dies before me, it goes to our children. Now, husband dies, and everything goes to wife number two. And wife number two said, I never liked her children anyway. And she changes the plan. With a trust, what you've decided becomes irrevocable when you die. Okay, so that, if you have a blended family, that's an instance when you might want a trust-based plan. So we talked blended family. Spouses often have children from previous relationships. We talked about the sweetheart plan. Okay, so we talked about all of that. Will your surviving spouse change the plan? Substance abuse issues. A lot of times, we all know someone, whether they're in our family or not, who is struggling with substance abuse issues, whether it's alcohol, drugs, or something else, gambling. And so what do? A lot of people will disinherit that person because they don't want to feed the habit, or they don't want to, cause further damage. But they also may want to make sure that person is taken care of. So again, how will the inheritance impact them? Will the money be spent to feed the addiction? Will they end up in a worse position? Do you disinherit them because of the addiction? So with a trust, that's where you can provide that if you leave it to them instead of outright, you say, put these funds in a trust, or put this house in a trust, and they can live there as long as these rules are met. If it's in the trust, if there's money in the trust, you designate someone else to manage it, tell them how they can spend it, and then it's not being used to feed that habit, but you can still take care of that person if you feel like you want to make sure they're taken care of. Dementia and self-serving caregivers. We probably all know someone with dementia, and we also know people who have been taken advantage of. I know when my father had Alzheimer's, he was in assisted living, and it wasn't a big taken advantage of, but one of the nurses who used to work with him, she used to sell noni juice. And my father had a closet full of noni juice. And so he was feeding her business. Basically, she was going to him, and she would take him to the bank sometimes, too. I was the trustee. I was the guardian, and so I handled things. But the 2021 Alzheimer's Disease Facts and Figures, a special report on race, ethnicity, and Alzheimer's in America showed that over 6 million Americans aged 65 and older have Alzheimer's. They expect that to increase to nearly 13 million by 2050. 1/3 of seniors dies with Alzheimer's or another form of dementia. And in the US, Alzheimer's and dementia deaths increased 16% during COVID-19 pandemic. So as we know, seniors are often the targets of fraud and victims of caregivers. Caregivers spend a lot of time with seniors, so they develop the trust and the access to assets. Children's creditors. What if your children have financial problems? That's the irresponsible spenders. Or what if they were sued? If you leave things to them in trust versus outright, then you can provide that creditor protection. You can have what we call a spendthrift trust that says, what I am giving them cannot be used to pay creditors, if they're going bankrupt, as collateral for that new Camaro, or anything like that. So you can put rules on what you're giving to other people if you put it in a trust rather than giving it to them outright. If you give them cash outright, it's going into their bank account and it's open to access. What if your children get divorced? There's a risk of generally inherited property is not considered marital property, and family law, divorce laws are very different from probate laws. And things are even changing in this area. But so if someone has inherited the family home, that's their property. But when it comes to family law, when you work, even if only one person is working, all the money and income that comes into that marriage in Georgia is family property. It's marital property. And so although the house may be inherited property, what if you start fixing it up? You know, you're using marital property to fix up that house or do things, and so that kind of muddies the waters and makes that open to attack. Now, I was in continuing education last week, and so they're talking about what courts may be doing now, even with the protections. But right now, the best protection is still, if you want to protect from divorcing, is to put it in a trust. But we don't know what the courts are doing right now as far as that goes. Trust protection for you and your heirs. So with a trust, you can plan for management of your property if you become incapacitated. You can avoid probate costs. You can protect against spousal remarriage or blended family issues. You can protect against fraud and self-interested caregivers, and you can protect against loss of inheritance due to addictions, financial issues, immaturity, or other issues. Okay. General types of plans. You cannot plan at all. The state has a plan for you. You still have to go through the probate process unless you don't have assets that have to be distributed. There's the possibility of family disputes because you haven't laid out what you want. When my dad died, I told you there's 7 of us. And my parents raised all chiefs, no Indians. And so if he hadn't said who was going to be in charge, that's what the fight would have been. And when we were at the funeral home, the funeral director, he was like, I'm amazed at how well y'all handled that. Because he was like, I've seen some things around this table. And that's what the fight would have been, who was in charge. But my dad laid it all out. And then the distribution. When you don't have your plan laid out, the statute says if you're married, it goes to your spouse, married with no children. If you're married with children, it goes to your spouse and your children, but your spouse gets at least 1/3. And then it goes to descendants. And if there are no descendants, then it goes up to your parents and down to their descendants. So the statute has rules for everything. And so that may or may not be the way you want it to go. So the first plan, and these are general, there's lots of different ways because your plan is particular to you. But the first type of plan is just the distribution determination. That's planning with a will. As we said, a will has to go through probate. But a comprehensive plan with a will-based plan will have the will, and that'll determine distribution after your death and nominate guardians for minor children, but it must go through probate. And then if you have life insurance, retirement plans, those are outside, okay? And those go by beneficiary designations. And then you'll have your health care directive, your HIPAA release, and your financial power of attorney. We talked about the power of attorney and the health care directive. The HIPAA release is, you know how you go to the doctor and they give you that privacy statement? So now they don't give it to you. They just have you sign that little screen, and then I ask them to print what I just signed. But that basically says that they cannot give out your private, personal records or information to anyone without your written permission. So the HIPAA release is written permission. It doesn't give any power. It just gives the ability for the doctors to talk to who you want them to. The second type of plan is probate avoidance. This is the revocable trust without a lid, okay? You always have a will still, because what if you have property that you forgot or didn't put into the trust? So the will go through probate and pour the assets into the trust, and then they'll be distributed the way you want according to the trust. And then you still have the same healthcare documents and financial power of attorney, and you may have life insurance or retirement. The Medicaid Asset Protection Trust. That's the irrevocable trust. Again, you'll have a pour-over will. Because it's a trust, it's a separate entity, so what's in the trust is protected, and there's no probate. It's only protected if it's been there for 5 years, because we talked about the 5-year look-back period. And then, depending on your asset mix, you may have both trusts. You may want to leave some things out that you don't want to go through probate, but you want to keep certain property out. So that can include, cash accounts. You may put some in the irrevocable and some in the revocable, and you'll always have a pour-over will. So the point is, you need to plan now. Failure to plan can lead to a loss of assets, cost incurred due to incapacity, loss of inheritance for loved ones. We know accidents happen every day, and everyone age 8 or older should have a plan. Okay, are there any questions? It depends on your circumstances and what your goals and concerns are. So the question is, why does probate take such a long time? The purpose of probate is to protect beneficiaries and creditors. So the probate process is to file the petition. So getting the petition together and all of that and filing it, that may take a month or a week, depending, if filling it out and getting it done correctly. Then notice has to go to all of the heirs. The court's not going to move until all of the heirs are notified. And so that they can sign waivers and acknowledgments. That makes it go much faster if you have them all. If people aren't in agreement, I've had probate cases where it took a year or two just to get the person appointed because of all the heirs, and especially if they've waited a long time after the person who died, because then you've got people who may have died since, people who died before, and the court's not going to move until everybody is served. okay? And so they will not, if you can't find someone, then they may allow you to serve by publication in the newspaper, but you have to have demonstrated to the court that I did this, and this to find this person and get them served. And some people just don't want to be bothered, so I'm not going to listen to you, I'm not going to sign, I'm not going to do anything. So I've dealt with that. And sometimes when there's no will, notice has to go in the paper that the petition has been filed if all the heirs haven't signed off. So getting everybody served is the first issue. But if it's going smoothly, sometimes you can file it in the court and get sworn in that same day. Then after you're appointed, notice has to go in the paper for 4 weeks to notice to debtors and creditors. That's to let debtors and creditors know that an estate has been opened, that this person has died, and give them an opportunity to file claims. Heirs and beneficiaries, and let me tell you, heirs are statutory. So the law defines who heirs are, and that's determined at one point in time, the date of death, okay? So, because I have one case where a person had 10 children. They didn't probate the will till 20 years later. And so some of those children have died, so they're saying the grandchildren are the heirs. The heirs are determined as of the date of death. Who was alive on the day you died? Those are the heirs. So if the person died later, their estate is the heir. If the estate hasn't been opened, then you may have to get a guardian ad litem appointed. So all of those things add complications. Okay, but notice to debtors and creditors, that has to run 4 weeks. Then for 3 months after the last date of publication, creditors can file. And so they file their claims, and then after that, you have 3 months to review the claims, determine which ones are valid, determine the priority of the claims, because if there's not enough money in the estate or assets to cover the claims, then everybody doesn't get paid, and it has to be determined the priority in the statute. The laws say what the priority is. So that's 1 month getting appointed in a good scenario, a 1 month publication, 3 months that the creditors have time to file their claims, and then after that, you pay the claims, and after that, what's left can be distributed to heirs or beneficiaries. Okay, and so I said heirs are statutory, beneficiaries are the people who are named in the will or the estate plan. And so beneficiaries don't have to be the same as heirs, they can be, and heirs can be beneficiaries, but they are two different things. So that's when everything is going well, that's a minimum of 6 months. Okay, on average, it's a 1.5 years. The court's processing a lot of cases. Things like COVID happened, and after COVID, I think a lot of the courts have had problems with turnover, and because I've had courts, Fulton and DeKalb are the big counties, and so I had a case where somebody left. The caseworker was working the case, and it was sitting on her desk. I had problems where we're trying to get to serve somebody, and they're so overwhelmed, and it causes a trickle down. Okay, so the court sent, this was actually a guardianship case, but it happens in everything. People make mistakes. They sent the service to the wrong address, okay? And they said, I didn't give the address. The petition had the address, but they used the wrong county. So then they sent it out, but they didn't get the notice back from the sheriff. Okay, the sheriff put the wrong zip code on sending it back, and they sent it to my client instead of back to the court, and nobody checked to see, oh, it came back. So there's all those things, but when things are going smoothly, like I said, minimum 6 to 8 months. If somebody files what we call a caveat, that's an objection to the will. If they think the will was invalid, they say, he had dementia, or my father wouldn't have left me out of his will, or whatever. Then the court's going to send it to mediation. All right, and so you got to wait for the court to do that. They're going to send it to mediation. You might work it out, you might not. If you don't work it out, then it's going to go for a hearing. Okay, and so sometimes all of that's before the person is even appointed. So all of those things cause time. And then if there's bills and debts, and another thing, although the creditors have 3 months after the last date of publication to file claims, if they don't file it till after that, that doesn't keep them from being able to collect. That just makes them lose their priority if you made the distributions based on what was already filed. Because some people say, well, they didn't file within the 3 months. The debt is the debt, and the estate doesn't get out of it just because a creditor filed late. Does that help? Yeah, okay. Any other questions? If there was a will, then no. If there was not a will, yes, an administrator has to be appointed. So the question was, he had his mother died and left the house to the children. And so the only way to transfer property that's titled in your name alone at the time of your death is to go through probate. And so if there's no will, that will be the intestate administration. An administrator will be appointed. That can be a family member. That can be the county administrator. If people are fighting, the court is going to do the administrator. If there's a will, then it's the executor who's appointed. And then when you are choosing your agents, it's good to talk to them and see if they want to do it. One of my best friend's father went to his cousin's funeral, and then he came back and he said, my cousin named me as his executor. I don't want to do it. So you name backups, but also it's a good idea to talk to your people to see if they're willing to do it. Pretty much. You've got court costs for filing. With probate, if you have a will, you can say in your will that your executor doesn't have to post a bond. All right. With intestate successions, they usually require a bond unless all the heirs are in agreement and they say they don't have to post a bond. But again, it'll be up to the court whether or not to require a bond. Attorney's fees. That's pretty much the same. It depends on the attorney. So all of those fees are still there. Any other questions? Yes, ma'am. Okay, I'm glad you asked that question. That's basically a gift. When you make somebody a signer on your account, you're not making them. So the question was, she has one child, and so I'm guessing you want everything to go to your child. Okay, so the question was, is it a good idea to put her as a signer on her account? And the short answer is no, that's not the best way to do that. When you add someone to your account, you are making them a co-owner. If they've got bad debts and people are coming after their stuff, well, that's now their stuff, okay? Also, if it's your house, if you decide you want to sell it, you got to get her permission. And you can't make her say yes. You might think you can. So. So it depends on how you're giving access. If you're doing it through your estate planning, if you have a power of attorney, then she is not the owner. She's an agent, okay? If you have a trust, she is not the owner. She is an agent. She's an agent who has the authority to manage your property, okay? So that's what the power of attorney and the trust. But you're not putting it in their name, okay? So if you add them to your account, especially we're talking about bank accounts, you are basically making them a co-owner, okay? And so then if they're a co-owner, if you're applying for Medicaid for nursing home care, you've made a gift of half of your account, okay? So all of those things you have to consider when you're doing those things. Thank you. Yes, ma'am. Yes. Okay, so the question was, if you make someone an agent under your financial power of attorney, when you die, do they still have authority? And the power of attorney dies when you die, okay? So with a trust, it has continuity. The property is owned by the trust, and while you're alive and well, you're the trustee, and you're managing it for yourself. If you're incapacitated, you've put provisions in the trust for who you want to manage it. And do you want it to be one, or you want two people working together? Who you want to do it if that person you named first can't do it. And then when you die, you also name successor trustees who can be different or the same as the incapacity successor trustees. And those are the people who can take over settling your affairs without having to go through probate, as long as you have properly funded your trust. Thank you. Right. And so she was making the point that, there may be someone who has a P.O. box, so you don't know what's coming. And after a year, the P.O. box because the person had died, it got shut down. You have to go through the probate process, whether there's a will or not. So we're talking about intestate administration or probate, in order to get access to the P.O. box. Because when you get appointed, you get letters of authority. And that piece of paper says that you now have the authority to talk to the bank. Because when you die, everything's supposed to get shut down. And it is illegal for a person who has a power of attorney to use it after you die. Okay, so everything gets frozen. If it's in a trust, it's not. If you've had a properly drafted trust, you've planned for those things. Yes, ma'am. Right. So they've been breaking the law. Yes. So here's the question. Here's the question. She was talking about when there's a will and people take a long time to probate the will. First, the law provides that whoever has possession of the original will, and the original will is what they don't want a copy, the court doesn't want a copy. If you can't find the will, the presumption is that the person revoked the will. Sometimes they will allow you to probate a copy, but you've got to prove a lot of things. So the person in possession of the original will, by law, has to file it in the court, whether or not it's being probated. There could be no property, but the will has to be filed in the court when the person dies. And what happens is you can inherit something after you die, because you might die before your parents or even your children or someone, and either by statute it may end up going to you, or someone may have named you in a will. Okay, and so then or as a beneficiary on their insurance, and they didn't name a backup. So then it will have to go through probate to go where your will says your property goes. Then it'll go according to the statutes. But the only way to transfer the property is to go through that probate or intestate administration. Yeah, a lot of people do that. They live in the house. Grandma had that good homestead exemption, but once it's finally transferred, they want all those back taxes. So, and that's how you have an heirs property situation. My great-grandparents had the family farm in South Carolina, and they had 9 children. My grandmother was one of those. My grandmother had 4 children. My mother had 7. My mother's brother had 5. And her sister had 2. And her other brother died young. That's just one line. Okay, and so now my great-grandmother died when I was in elementary school. Okay, so but just a few years ago, we're talking about generations later, they've never probated any wills or did any intestate administration or anything, and we talked about heirs having to be notified, and I just described one line of possible people who are entitled to that property. We had 8 other lines. And so you ended up in court, you end up, it's very interesting because crazy things happen. One of my great uncles had a foster child. And when the family was fighting over the property, they were in court, and they were all old then, and someone said the foster child was named Carol. Okay, so somebody said, oh, Carol's an heir. But she wasn't. She was never adopted. And so, but she ended up getting put in because everybody said, yes, she's an heir. And so then later, Carol's the kind of person, she fancied herself an actress. And so at one point, she was living with my great uncle, and she was taking him to the bank. She bought a Mercedes. She didn't even have a driver's license. She used his money to get dental implants. And then my mom kind of shut that down. But now, 20 years after he's died, his wife, she was an educator. And when the older people went in court fighting over the property, they didn't want to pay attorneys or anything. They didn't. So his wife, he died before his wife. Everything went to his wife. Okay, so his wife had a will that said everything went to this foster child. Okay, so years later, the second fight in court, I started pulling stuff. It's too late to do things. That will was signed with an ex, which it can be, but she was an educator. And when I started calling doctors, she didn't have capacity when she signed that will with the ex. Okay, but it was too late because years before in the first fight, they had already had the court put in. So now, the attorney, which we find out later that she had, I actually think I've heard about black families losing land in South Carolina. Well, this attorney's name was Thurman in South Carolina. And so, and she was trying to force a sale of the property to get money. She's out in England now, and I guess she needed money. And so Thurman's bringing a lawsuit for her. I know she can't afford Thurman. And my mom, she believes in the good of everybody. She built a log cabin on the property. And but after she did that, that's when the first fight came. She had asked everybody if it was okay, but then somebody fell on hard times, and they wanted to sell the property. And, of course, they wanted to sell the piece with her log cabin on it. But so now we're fighting Attorney Thurman, but now, and so they end up, dividing the property, and that's because they didn't follow through and do what needed to be done at every step. Okay, and then we were just talking about, I said, well, what happened to Carol's share of the property? She got like a quarter of the property. And they said Thurman bought the property. So he probably sought her out. So, and I think he was trying to get the rest. But my sister's an attorney, and she's one of them fancy New York attorneys. I'm not a litigator, but she was handling things, and so he didn't get what he wanted. But that's what happens. You need to probate every step of the way, because that's how we're losing property. And, we lose it to tax sales because whoever's been paying the taxes died. That happened on some property. They died, so nobody's paying the taxes. Okay, so then somebody buys it on the courthouse steps for a couple $1,000s. So you need to probate or administer at every step of the way. Any other questions? Yes. I don't really know the answer to that. Because there's no consequence, I've heard 4 years. That's something I actually need to look up. I just go and probate. So I don't know the answer to that. So, but it should be done as soon as possible. I saw another hand. Mm-hmm. You can't sell it until you go through administration. So the question was, you got an heirs property situation where grandparents own property. The first grandparent died, it wasn't probated or administered. The second grandparent died, it wasn't probated or administered, just like my family, okay? Then there's 12, and it's still not probated or administered. And then each of them may have been entitled to a share. And then some of them die, and theirs wasn't probated or administered. And so the question is, how do you sell the property? Because the person who's been paying the taxes is now sick and not paying the taxes. Okay, you've got to go back and probate and administer. And there may be several estates now that you have to probate and administer before you can dispose of that property, because the purpose of probate and estate administration is to protect the rights of creditors and beneficiaries. So it has to be probated at the grandparent level, and it may be grandpa who died first and then grandma who died next, if grandpa had a will, okay? And it depends on this. If it's Georgia, I know those rules, but different states have different rules. But that's a big mess that's and a big expensive mess, right? Right. Grandchildren become heirs, great-parents. Well, they're not the heirs of the grandparents. Heirs are determined as of the date of death. And so, but the other thing that happens is, property, especially when we talk about these rural areas, the younger people are not interested. But there's a finite amount of land, and they're not making any more. And we know the East Coast is becoming saturated. And so all those things that used to be the sticks are now valuable property. And people like Attorney Thurman want it, or people are trying to I shouldn't be. But I was speaking the truth. That's what I heard. So yeah, those are the kinds of things that happen that we lose property. Yeah. Well, it depends. There's got to be a determination of who are the heirs and who's entitled to notice. And so, but yeah, so that's what happens, and that's what can cause the probate process to take a long time. So. Right. Yeah, it can get very expensive. So, all right. Well, I see another hand, two hands. And then I think this will probably be it. So, filing it in court is not probating it. A will, it does not become. So the question was, if you have a will, and she said she did a will, and the attorney said he's going to file it in the court. So he's filing it for safekeeping. A will does not become effective until after you die. Thank you for your question. So, and a lot of times, like if there's a lost will, you can't find it, check the court, because it's possible that it was filed in the court. But when you do that, you have to make sure that if you change your will, you go retrieve the old one, tear it up, and put the new one in place. Okay? And so, but yeah, you can't. She asked if she should probate it now. It can't be probated until after you die. It depends on the court, but I think it's like $15 to file it for safekeeping. There was another hand over. I saw you, sir. There was another hand over here. No, I suggest that you plan. And I suggest that you confer with an attorney to determine what type of plan is appropriate for you. It may be a will. It may be a trust with a will. It may be something else. Okay, but it's going to depend on your circumstances and your goals and your concerns. So it's not a one-size-fits-all. And so, and when we talk about doing it yourself, they've got all those forms and stuff out there, and people mess up a whole lot of things because they don't understand what they don't understand, and they just gloss over it, and they create all kinds of things or think they created things, and there are terms that are used in legal language that are used in everyday language but have very specific meanings, okay? And so I had someone who, when I mentioned about the joint tenants with rights of survivorship, if it's not on the deed, those words, rights of survivorship, then it's tenants in common in Georgia. So they went and did their own deed and made sure the words joint tenants with rights of survivorship were on the deed. But the language of the deed did not create joint tenants with rights of survivorship. So now she's got to pay attorneys to figure out what exactly this will does and make sure it's right, or she may have done something that she didn't intend to do and created powers in other people. All right. Were there any other questions? Yes, sir. If I'm going to have to ask you if it has to do with your particular family story, we've got to, okay, so. Okay, I'll tell you our process. Those are the questions. Our process, the fundamentals workshop, which is what you're doing today, okay? Then we have what's called a strategy meeting, consultation, and then if you decide to move forward, you engage. That's signing the engagement agreement, paying the fee. Then after that, we have a design meeting. So you've completed a questionnaire talking about all your family. Does anybody have disabilities? Are you married? Are there grandchildren? All that kind of stuff. All of your assets. Do you have insurance? How is it titled? Who are the beneficiaries? People say that's kind of personal. It's very personal. Go ahead. And I recommend it. You don't have to get a lawyer, but you can make a big mess, okay? So this is our process. And so with the design meeting, you've completed your questionnaire, and then we sit down and we discuss, actually during the strategy meeting, we're discussing your goals and objectives and kind of get an idea of what it is you may need. And then if you decide to move forward, we meet for a design meeting, and that's where you say who your agents are going to be, how you want things distributed, who you want to manage your property, who you want to manage your care, all that type of thing, who you want to take care of your children. Then we draft, and after that, we have a review meeting to go over, make sure it's accurate, and then we have a signing meeting. If you do a trust-based plan, that's just the beginning. After you put the plan in place, you have to fund it. That is putting the property into the trust. And that is where many, many people do not follow through. And if your property is not in the trust, if it's not properly funded, then it's going through probate to get into the trust, okay? And so it's good to make sure you take that second step. Your attorney can help you with the funding. Often people don't want to pay their attorneys to do the funding. My firm is in the process of putting what we call a maintenance plan in place where we will have, that's for next year, but we will have annual education on changes in the law, because planning is not a one and done thing. You should review your plan at least once every 2 or 3 years, or when there's a change in life circumstances, a birth, a death, someone you named as an agent is no longer a good agent, you've moved, changed jobs, whenever there's a life-changing circumstance. And so with our maintenance plan, we will have annual reviews and determine if you need to update. And we will also have education for funding and assistance with funding and updates in the law, because sometimes the laws can change to change taxes, to change different things that maybe impact your plan. I think that's it. So, and also, a lot of times nobody has asked, which I'm surprised, they ask about pricing. So there's lots of different ways to plan, and it depends on your circumstances. So I will give you the most common in our plan, and I'm talking about comprehensive planning, not just Sometimes people just want a power of attorney. So there's that, but then there's the comprehensive plan that we talked about, those ones 1, 2, 3, 4. And so the type 1, the will-based plan for distribution determination, for a single individual is $3,000 in general, and for a married couple, we take half off for the second spouse. Type 2, the revocable trust-based plan, for a single person is $5,000, and for a married couple, we take half off. Type 3, the Medicaid Asset Protection Trust without the revocable trust is $7,000, half off for the second spouse. And type 4, where you have the 2 trust, is $10,000 with half off for the spouse. We have bonus offers for people who are interested in moving forward. If you schedule today, we're providing free consultations. Okay, so I usually charge $400. Right now I've got a special at $350 for the consultation. And then $250 off if you decide to do a comprehensive plan. And those are available consultation times in the month of September. So are there any other questions? Yes, ma'am. Yes. So that is something that will depend on your particular circumstances, what the best thing to do is. So that's a question that's very personal and will require a consultation. All right, well, I thank you for having me here today. I will be here if you want to talk later. And if you have organizations, I like to educate, okay? And so if you have organizations that would like a presentation, I do presentations also on special needs planning, long-term care planning, a lot of the different things that we talked about today. All right, well, thank you very much. I appreciate your having me today.